All right, Megan, are you about ready?
Sure am.
All right. Um, all right, well, I'll pass it on to you for student discipline.
All right, sounds good. Thanks, Mark. Hi, everybody. My name is Megan. Visual description of me, I am a brunette woman, 31 years old. I'm wearing a blue top and a gray blazer. And I'm very happy to be here talking to you about student discipline today. A little bit about me. I work for AW in our Michigan office. I'm one of our Michigan attorneys. My primary components of my caseload are student discipline and juvenile justice, so things involving the juvenile justice system. And that's kind of the bulk of what I do here. So again, really excited to be talking to you guys about kind of my passion and my practice. Um, oh shoot, a fun fact about me. I'm a Sagittarius. Can you believe it? But in all seriousness, when I'm not working with kids and doing this work that we love, in the summertime, you can usually find me out riding my motorcycle. I won't be doing that after things end today due to the wildfire smoke and the heat, but it is a fun thing that I get to do here in Michigan. And Renee, if you don't mind switching slides, we can go ahead and get started. Okay, so underlying law for student discipline. Now, I know you guys have heard a lot in the last few presentations about Supreme Court cases and constitutional law. I'm not going to do a deep dive here. I really want to focus more on what to expect at a hearing. But in terms of a disciplinary hearing, these are the things that you're going to use as your underlying basis for the law. The first thing is the 14th Amendment to the Constitution. That's known as the Due Process Clause. Your student, just like everybody else, has due process rights. And that was ultimately fought out and determined in a Supreme Court case in 1975 called Goss v. Lopez. It's a bit of a read, but essentially, long story short, the case ended up holding that if a school is going to suspend your student for a significant period of time or expel your student, that triggers their due process rights. And what that means is that the school has to provide written notice that this is going on, and they have to provide an opportunity for the student to hear the allegations against them and to provide a defense. And so they have to provide that through a disciplinary hearing. Michigan's specific codification of this law is known as the Restorative Justice Act. That's MCL 3801311. Every state is going to have their own codification. For the purposes of this presentation and my practice, because I practice in Michigan, I've focused on Michigan here. But the tips we're going to talk about today are really impactful whether you're having a student disciplinary hearing here in Michigan or in any other state. So I want to make sure that folks who aren't here from Michigan today still know this presentation is still for you. This information is still for you. And I'm going to pepper in a few fun facts that I've learned from our other attorneys here who do practice in Ohio and Pennsylvania, things that I've learned about student discipline there. So hang tight. Even though we're focusing largely on Michigan, we're going to include information for all three. And if we can move to the next one. All right. Let's talk about the process itself. I want to make space for the fact that, whether you're here as an advocate, an attorney, maybe you haven't had experience with these disciplinary hearings, and particular if you're here as a parent, if you've not had experience with a long-term, significant suspension or an expulsion for your student, this process can be very overwhelming. So my goal for today is I would like you guys to be able to walk out of this session feeling empowered in this process and feeling like you understand all the steps that are at play here. That's the goal. And that's whether you were to go forward on your own for a disciplinary hearing or whether you were to retain counsel. We want to make sure that you understand this process from start to finish. So to begin at the beginning, schools have large discretion to suspend a student for short periods of time. I've seen students who are suspended for 3 or 4 days because they had a simple dress code violation, and that may sound a little extreme, but it's perfectly allowed. That discretionary period is 10 school days. That's typically when they trigger the due process right for the student. Now, we're going to talk in a bit about the hearing steps. I do want to pepper in a fun fact here about Pennsylvania. Pennsylvania is particularly progressive, I think, in their student discipline law, in that students and parents are actually entitled to an informal hearing. And we'll talk about what that looks like in a bit. But they're entitled to that when a suspension exceeds 3 school days. So you get sort of a mini hearing once you're at that 3-day threshold in Pennsylvania. You do not receive that in Michigan or Ohio, but that's why it's so important to know the rules of the state that you're in. Once a suspension does go beyond that discretionary period, the student becomes entitled to this disciplinary process. Now, if your student is on an IEP or a 504 plan, and it doesn't matter which one, if they're on a plan, before a disciplinary hearing is held, before the school can impose discipline beyond those 10 days, they're required to schedule and hold a manifestation determination review, otherwise known as an MDR. All right. And if we can just switch over to the next one. Thank you, guys. So what is an MDR? It's pretty simple. The IEP team or the 504 team, parents, advocates, these are going to be the same folks that are in the room when you have these meetings, when you're crafting, these appropriate supports for your students. So everybody at this table for the MDR should be familiar with your students' disabilities, with their behavioral challenges, if there are any, and with their needs as a whole. But the team is going to convene. They're going to look at the allegations against the student. They're going to discuss the behavior at play, and they're going to consider if they feel that the behavior was the results, whether in whole or in part, if it's somehow related to the student's disability. If they determine that the student ultimately it was related to the disability, yes, they engaged in this behavior, but it's disability related, that student is going to be allowed to return to school. They're not going to proceed forward to a disciplinary hearing. And that's really important to note, because if you are unsuccessful in an MDR, that is, if the IEP team or the 504 team convenes and they say, hey, we looked at everything, guys, and we just don't think that this behavior was related substantially to the student's disability, so we're going to find that it was not a manifestation. At that point, then the student ultimately is still entitled to the disciplinary hearing process. It's going to kick off as though it would for any student who did not need an MDR. All right, guys, next slide. Thank you. Okay, so let's talk about a disciplinary hearing itself. Many of the parents that I speak to have never been to one, and that's a good thing, right? Nobody wants to spend their time constantly going to disciplinary hearings. It's never a good thing. You never want to hear that your child is in trouble or facing consequences like this. The downside to it, though, is with very little experience dealing with it, like I said before, this can just be a process that's really overwhelming. I want to make sure that you guys understand that there's some nuance state by state, for sure, with how these things are handled. But even within your state, district by district, these are going to be managed a little bit differently. Every district I've worked with or had a case with has had their own process, their own, policies that they lay out in the student handbook, and they've had their own way of meeting their due process obligations. So I'm going to give you guys kind of the big picture stuff, but recognize that, things might be a bit different district by district, which is why it's really important to know your district's policies and be prepared when you're called in for one of these hearings. They can take different forms. Every district has their own method for organizing them. Now, some districts will conduct an initial hearing. Oftentimes you will hear it called an informal due process. And what this is really just a building level meeting. Typically we'll see administrators for the building that your student is in. So think, maybe a principal, maybe an assistant or a vice principal. Sometimes it may even be the school resource officer. We often will see that in discipline cases for older students. So just be prepared. Those are the kinds of team members that will likely be at this building level meeting. Oftentimes, I find that districts will frame this meeting as an opportunity for a student to tell their side of the story. And that can be very beneficial. There are times when I've said, okay, let's go in and let's do this meeting and let's have this conversation freely and candidly. And oftentimes that can result in building level discipline, but they may decide not to refer it up to the district for long-term suspension or expulsion. So be aware of that. It can be a good tool to have in your toolbox. Now, the one time that I caution folks against attending these meetings or having their students speak at these meetings is if there's a possibility of criminal charges coming along with the behavior that was alleged against the student. Again, we typically see this more at like the high school level, but just as an example, recently I had a matter where a student brought a knife to school, and that knife was 3.5 inches, which under Michigan law is a quote, a dangerous weapon, which means that they could face ultimately criminal charges for bringing that in, even though they didn't use it, they didn't hurt anyone. The act of having it is in itself a crime. And at that point, you know, you have to do a cost benefit analysis of, do you want your student to make a statement that may possibly incriminate them down the line? These are all things to consider as you move through this process. If the building level hearing doesn't go in your favor, meaning if they don't say, hey, we're going to suspend kiddo for a week and bring him back, if they tell you we're going to refer this to the district for discipline, this is what that means. Typically, it will get sent to the superintendent's office. The superintendent will review the notes from the informal hearing. They'll review any evidence that the district may have gathered about the behavior being alleged against the student, and then they will make a recommendation to the school board for discipline. Oftentimes, what we will see for those is either a long-term suspension or a recommendation for expulsion. Now, this is the stage at which your students' due process rights are really kicking off. This is when you're going to start preparing for a real formal hearing. All right, if we can just switch to the next one. Thank you. All right, so guys, when you're at this point, there are 3 things that I want you to do. Number 1, redefine what a win means to you. I meet with folks so often who are caught up in this whirlwind of what's going on with their student, and it's completely understandable from an emotional standpoint. But we have to take a logical step back, and we have to define what a realistic win looks like for us. When your student is facing an expulsion, typically they do not get there because there is no evidence against them, right? That's why we have these built-in processes like the MDR, the informal hearing. Usually there's some set of bad facts that we're working with. It doesn't mean that your student is bound to be expelled, but what it does mean is that the odds of him, you know, getting off scot-free and coming back to school tomorrow are pretty slim. We have to take a look at the facts and make a realistic expectation of what we want to push for so that we can get the best possible outcome for this student. And when you do that and you redefine a win and you realize this process is pretty nebulous, it doesn't have to be all or nothing, you have a lot to work with in a disciplinary hearing. So step 2, always consider your audience. Especially when dealing with a school board, it's usually a diverse array of people. It can age in ranges and work experiences. Age range can vary, work experience can vary, values can vary. But the one thing that these folks all have in common, even if they do not have children themselves, is that they were once your student's age and they were once in school at that time. That's something that you can use. Don't be afraid to relate to a school board on a human level. And that's often something that, you know, when I discuss these hearings with parents, I think folks are usually a little bit afraid or intimidated to do. Don't be afraid to do that. Consider your audience and recognize that, you know, they have experiences being the same age as your student. They have experiences being a student. Many of them have experiences being a teacher or an administrator. And don't be afraid to kind of lean on those and that common knowledge. So the third and final thing to do is to prepare with proficiency. And what I mean by that is, don't leave things to chance. We're going to talk about some elements further on in my presentation that whether you're in Michigan, Ohio, Pennsylvania, I would say any of the 50 states, you should be incorporating these elements into your argument and your advocacy for your student. And you want to be proficient in every element. You want to know not just what the good facts are for you, but also what the bad facts are, what the facts that are a little bit more difficult to justify or explain, because I guarantee you, the school board is going to know those, and they're going to have questions for you and or your student about those bad facts. We want to be proficient in our facts. We want to be proficient in our elements so that we come prepared and we come correct to advocate for our student. All right, next slide, please. Okay, so just a quick overview. I know I'm throwing a lot of information at you guys. Really, there's 4 steps that you need to be worried about. That first step is that building referral. After your student is initially disciplined, they may say, hey, we want you to come in for this informal hearing. Step 2, if that informal hearing results in a further discipline referral, that's going to go up to the school superintendent. The superintendent's going to conduct that review we talked about. They're then going to pass that on to the school board with their recommendation. At that point, the school board has the disciplinary hearing, and I'll walk you through how those work now. And they're going to make their determination. Oftentimes, they'll submit it to you in writing several days after the hearing. It's pretty rare that I'll get a determination same day, but just be aware that you are going to get in writing, once the process has ended, a formal determination from the school board about your student's discipline. All right, next slide, please. Okay. So before I touch on the Michigan restorative justice law, it's pretty meaty and I've got a lot of information I want to give you guys. I'd like to pepper in there my fun fact about Ohio, because I think this is very interesting and again, kind of progressive. It's not something we see in every state for student discipline. In Ohio, if a student is suspended for an out-of-school suspension near the end of the school year, that suspension under Ohio law cannot carry over into the next year. So for just as an example, let's say we have a disciplinary hearing and your student is disciplined for 90 school days, but they're disciplined in late April. Well, there's no way we're going to get 90 school days out of the way before September. They can't be suspended when school starts again in September in Ohio. Now, that doesn't mean that they won't be punished. The superintendent can come up with alternative ways for the student to serve the suspension. Oftentimes, you'll see a superintendent impose community service hours or something like that. But it's just a very cool thing to see that in Ohio, a student's discipline is not carrying over into the next year. In Michigan, that is not the case. If you're suspended for 90 days in April, you're going to serve those 90 school days before you can come back in most districts here in Michigan. So just a fun fact about Ohio for my Ohio people in the audience. Circling back to Michigan, let's talk about the restorative justice law. Here in Michigan, this law is really the basis. It's everything you're going to base your student discipline argument around. And not just you, the school district has to consider these factors. They have to be able to prove that at your student's hearing, they didn't just list the factors, they talked about them individually and considered them before making their determination. And they have to consider these 7 factors under the restorative justice law anytime they are suspending a student beyond that 10-day period or imposing an expulsion. So the law itself was really meant to ensure that discipline was fair. They wanted to make sure that it was appropriate. If a student is being suspended for a long term or even expelled, the least that we could do, right, is make sure that that's fair and appropriate. And the idea was also that there are restorative justice measures that we can use to ensure that a student's behavior, while maybe inappropriate, can be safely addressed, but still keep that student in school. And we're going to go through what some of those restorative justice measures can look like, because I know that's a very broad statement, but just be aware that's really where the intent was. The intent of this law is to keep kids in school as much as possible. And I know I speak for all the panelists here when I say that's what we want. All right, if we can move to the next slide, we'll hit those 7 factors. All right, so these are your 7 factors. If you remember nothing else from my presentation, and again, even friends in Ohio, Pennsylvania, Indiana, anywhere that y'all are coming in from, my opinion is honestly, I don't think you can go wrong addressing these 7 factors. Even if you're not in Michigan, even if your state doesn't have a law codifying that the school board has to consider them, make them consider them, because these 7 factors are really comprehensive and they're going to cover just about all the considerations that you could have for your student. So the first factor is the student's age. Next is their disciplinary history. Third is if they have disability status. Now, this is even in the case that your student had an MDR and maybe we didn't come away with a fruitful result from that MDR. The school board still has to consider whether that student has a disability and how that impacts them. Now, they also have to consider the seriousness of the behavior alleged against the student. And the next factor, I really think you could kind of roll these 2 together. They go hand in hand. The next factor is, did the behavior create a safety risk? Now, the important thing I want you guys to be aware of with that factor, and we'll get into more detail, but just keep in mind, safety risk applies not just for other students in the school. They also want to consider if the student presents a safety risk to themselves or to staff members. So just be aware that that may come up. Okay, so the sixth factor is restorative practices. And again, we're going to talk about what that looks like, but they're considering whether restorative practices have been used with this student at all in the past. And the seventh factor is lesser interventions. And what does that mean? Again, I'll get into some examples, but essentially we're asking ourselves, is there something less than a long-term suspension, something less than an expulsion that could appropriately address this student's behavior so that we can keep them in school, or if they're going to be out of school for a while, get them back more quickly. All right, if we can swipe over to that next slide. Awesome. Thank you so much. So the first factor, let's talk about age. One thing that I see folks do, and it's not through any fault of their own, it's understandable. But one thing I see folks do a lot is they start off their argument by saying, members of the school board, student A is only X age. And personally, I don't like that approach. I never want to do that unless the student is truly too young to understand actions and consequences, which I would say is very, very early elementary level. I would be deeply concerned if a student who was too young to understand actions and consequences made it all the way through this disciplinary process to an expulsion hearing. That's an error on the district. But in general, I try to tell folks to avoid using that. Personally, in my practice, instead, I try to focus on age-appropriate reactions, age-appropriate disciplinary measures, and you want to ensure that you're explaining the student's age really as a function of their own thinking, their own cognitive capacity, their own decision making. And like I said, don't be afraid to kind of lean into this one. We want to do it in a way that feels respectful and authentic, but it can be very effective. Just as an example, I mentioned to you guys earlier, I did recently have a student disciplinary matter where a student brought a knife to school. To give you guys a little bit of background, the student was in junior high. They had been experiencing some fairly intense bullying. They had reported it a couple times, but nothing really came of that. And the bullying progressed from verbal to physical. They started getting pushed, punched, nothing very intense, but there was physical hitting. And the student started to feel a little bit unsafe. So they brought the knife with them to school. And they brought it as, in their mind, what was a mechanism of self-defense. Ultimately, thankfully, they never used it. They never brought it out on anyone, but they were found with it in their backpack and it became an issue. So instead of presenting this to, ultimately the school board and saying, hey, this kid's only 12, we can't write it off like that because something really bad could have happened. Instead, what we started talking about was how he was feeling at his age. And I would imagine everyone here has been 12 years old before. I know I speak for myself, at least when I say that was a tough time in my life, right? And you sort of feel like you're under a microscope. And when you're that age, everything feels louder and more difficult and more hurtful than it might feel when you have more life experience. So what we did was we asked everybody on the school board to close their eyes with us for just a moment and think about when they were 12. And we just asked them to approach the days leading up to this incident through the lens of their 12-year-old self and what they would have felt was an appropriate reaction or reasonable reaction. And we found that to end up being very effective. There are many ways that you can utilize the age as a factor. I just don't want people to be afraid of it or try to say, oh, they're just this age and move on, because that can backfire. We want to give it some context so that they're really thinking about that and trying to approach things from your student's perspective. Next factor is their disciplinary history. This probably sounds obvious, but if your student doesn't have significant disciplinary history, lean on that, guys, because that is a golden ticket. That means that this incident was a one-off and it doesn't need to lead to an expulsion in order to be addressed. If your student does have significant disciplinary history, or even maybe a history with just one or two incidents, but they were similar in nature, the school board is going to lean on that as a justification for a longer term suspension or an expulsion. We want to address that head on. get ahead of those bad facts. Now, one thing you can do with it is you can divert some attention away from it and sort of take the wind out of their sails a bit. For example, you can say, we acknowledge, we recognize that our student has this disciplinary history. Here are the following things that we are doing, that this student is doing to address their behavior and ensure it doesn't happen again. I always recommend to folks who are going up for a disciplinary hearing, have your student engaged in counseling, have them engaged in some form of community service. And it doesn't have to be work that feels like, drudgery to them. It can be something like volunteering at the animal shelter. We just want to show that they're taking it seriously, that their support systems are taking it seriously, and that we're making efforts to improve things for the student such that the disciplinary history should not be as big of a concern. So that's one thing I definitely want y'all to keep in mind as you go through this process. Next slide, please. Thank you. All right. Safe. It should be disability. There we go. Thank you. If your student has a disability, by this point in the process, you should likely have already gone through an MDR. Don't be afraid to make your record and push back and say, look, we believe that our student's disability influenced their behavior that day. Oftentimes you will hear counsel for the district, if they're present, or maybe the superintendent, whoever is leading this disciplinary hearing may tell you, we're not here to litigate the MDR. That doesn't mean we can't talk about the student's disability. In fact, they have to let you talk about the student's disability. One way that I get around this is it's all about phrasing. I'll say, hey, we recognize we had an MDR. We respect your determination. Respectfully, we do disagree. Here are the ways that this student's disability has influenced them in the past and has impacted their decision-making and impacted their decision-making and their determination on what behavior was appropriate during the incidents that are alleged here. So just remember, even if the MDR didn't go in your favor, that doesn't mean that you cannot advocate for your students surrounding their disability and their needs. The impacts have to be considered. It's one of the 7 factors here in Michigan. Again, in Ohio and Pennsylvania, I don't practice there, so I can't speak to that, but I would still encourage you, to utilize that factor and all the 7 factors, because it really creates a more robust picture of your student, their needs, and their state of mind at the time that the behavior occurred. So seriousness of the behavior. Look, if the behavior is not serious, definitely emphasize that. But let's be real, guys. If a student is facing expulsion or a long-term suspension, it's probably some kind of serious allegation, right? Now, it may be that your student didn't think it was serious, or that they didn't intend for it to be serious, or maybe they were joking, whatever that may be. At the end of the day, you still have to make space for and acknowledge that the allegations are serious. We're not going to get anywhere with a school board by saying, hey, this behavior is not serious, we shouldn't even be here. We want to redirect them to really focus their energy on how your student is changing the behavior and how we're supporting the student so that the behavior will not occur again, and they should feel safe letting the student return to school. One thing I definitely want to make advocates, attorneys, parents across the board aware of, I have gotten this question at every single student disciplinary hearing I have ever done. And I personally term it to folks as kind of a trick question. Many times they will ask you some iteration of, what should we do when a student is accused of doing these things? And your gut instinct, understandably, of course, is to defend your student. Many people just gut react and they say, well, I mean, you shouldn't have investigated this student. You shouldn't have brought him to a hearing. This is ridiculous. That's not the right answer. And you may feel that way, but I want you to lock that up and not say it, okay? Because there is one correct answer to this question. And if there's only one piece of advice I could give y'all about going through a disciplinary hearing, it's that this is the answer to their question. What should we do when a student is accused of behavior like this? The correct answer is you should do exactly what you're doing. You should investigate. You should bring the students so that they can explain their side of things to you. You should make sure that school is safe for everyone. And when you say that, you take a little bit of that wind out of their sails in terms of arguing that your student is unsafe or unreasonable. When we go into these hearings, we have one objective, and that is that we have to be the most reasonable people in that room. And if we don't walk out of that school disciplinary hearing with everyone feeling like we were reasonable, then we have lost, no matter what the outcome is. You've got to appear reasonable. And so I understand, folks, many people have that emotional reaction. Be prepared that they're going to ask you these questions, and we can't answer them from that place of emotion. We need to be logical and clear, and we need to be very reasonable and say, you should be investigating. And here's why our student is safe. Here's why our student is not a safety risk. Here's why our student should be allowed to return. So just keep that in mind. And like I said, be prepared for that kind of trick question if you're in this situation. All right. Safety risk. Now, again, these factors kind of bleed into each other. It goes hand in hand with seriousness of the behavior. If the behavior put other students, staff members, visitors, or your student themselves at risk of any kind of physical harm, the school board is going to consider that a safety risk. It's just a fact. And you know your student better than anyone. You may feel deeply in your heart of hearts, my student is not a risk to anyone. But you have to approach it again from that logical standpoint that a school board is working with the facts that they've been given. And we have to acknowledge if behavior created a safety risk in that moment. Don't shrink away from acknowledging that a behavior was serious or a safety risk, because if we do that, it can really backfire. I think what we want to focus on, the reality is these bad facts, we can't change them, right? So we want to pivot. We want to take that wind out of their sails. We want to acknowledge, hey, we recognize this behavior. It is a safety risk, but here's how the student has made changes. Here's how the family support system has made changes. Here are the changes that we're proposing in their supports at school so that this safety risk never occurs again. You will look much more reasonable if you do that, and they will be more inclined to consider your argument at that point. So I want to talk to you guys about the last two factors, restorative practices. Here's the reality, in my opinion, at least practicing in Michigan, and during the Q&A, I'm hopeful maybe our attorneys in Ohio and Pennsylvania can give me their opinions. In my opinion, in Michigan at least, most districts fail to utilize restorative practices kind of across the board. It's usually not done when a student is having these initial disciplinary issues. So if you're before a school board for your student's first ever disciplinary hearing, odds are that they haven't utilized restorative practices. And while that's disappointing, we can really use that to our advantage. You can make the case for restorative practices to be utilized in place of a suspension or even an expulsion. So what is a restorative practice? It kind of is what it sounds like. It's a practice that a school engages in to restore the relationship between the student and the school. And that can be if there was a victim in the situation. Let's say your student punched another student. That can be restoring the relationship between the two students, or if there was a staff member involved. Once we restore that relationship, it takes care of these other concerns and factors. There's no safety risk if that relationship has been restored, right? So what does a restorative practice look like? It's really different in every district. And the good thing about it is you can kind of mold them to what you want them to be. Sometimes it can be, some districts call it a talking circle, which really is more of an informal meeting where maybe the student might meet with their parents and the school counselor. Sometimes I've had districts offer joint counseling sessions between a student and their accuser. Like I said, if the behavior involves another student. Another option, some districts have utilized peer mediation, in which, there's adults supervising, but ultimately a peer who is a friend to both will try to mediate the situation and repair the relationship between the students. Another factor that we've used a lot as a restorative practice in multiple disciplinary cases is a check-in with a trusted adult. If there is an adult at your student's school who they trust, who they have a good relationship with, and they would be willing to do a daily or a weekly check-in with your student, don't be afraid to propose that, because that can really set the tone, number one, for a successful day for your student. But that can also take care of a lot of these concerns about safety risk and behavior reoccurring if they were to permit your child to return to school. All right, let's do the last of the 7 factors. Lesser interventions. So again, this kind of goes hand in hand. In the same way that seriousness of behavior and safety risk go hand in hand, restorative practices and lesser interventions go hand in hand. So very likely, if your school has not utilized restorative practices, they also haven't utilized a lesser intervention at this point. The question that the school board has to consider is, would a lesser intervention appropriately address the behavior, or is the only appropriate response this long-term suspension or expulsion. So some examples of lesser interventions that I've seen used in my practice. For my student who brought a knife to school, we agreed to daily backpack searches. We've had cases with mandatory check-ins with administration, kind of like we talked about with a trusted adult, but that may be a daily check-in with your principal. It's oftentimes something that your student is not thrilled about, but at the end of the day, it gets them back in school. And so I always advise folks, let's agree to those and let's participate in them in good faith. Now, another option, sometimes I'll see districts utilize this, especially in the era post-COVID, online schooling for an agreed upon time, and then a gradual transition back to in-person school. Depending on your student, on their needs, and on their experiences with online schooling, this might be a good idea. And like I said, it's something I don't want you to shy away from bringing up. These 7 factors are the tools in your toolbox to advocate for your student. Don't shy away from suggesting a lesser intervention. Don't shy away from suggesting, hey, we might be willing to agree to mandatory check-ins. Don't shy away from asking for restorative practices. If they've not been used, they need to be used. And that's your right to request that. So just keep that in mind. Like I said, I think regardless of what state you're in, these 7 factors create a really comprehensive blueprint for success at a disciplinary hearing. All right, next slide, please. All right, bad facts and what to do with them. Guys, I know we talked a lot about this, but again, I can't emphasize this enough. If your student is at a disciplinary hearing, odds are, I would bet my bar card that there's a bad fact in there, right? And we don't want to turn away from those. We got to face them head on. We need to address them in a way that appeals to the school board, that shows that we're reasonable and helps to convince them of our side. It's all about that glitter that we put on the pile of mud. Don't be afraid to get in there and deal with those bad facts. That is often the thing that makes us successful at disciplinary hearings. All right, so 3 takeaways. I know, like I said, I'm throwing a lot at you guys today, but if there are only 3 things that you take away, I would hope that they are these 3 things. 1, you are the advocate that your student needs. How do you become the best advocate you can be? 2, you arm yourself with information. Those 7 factors. Be prepared to address the good facts and the bad facts as they apply to each. Don't go into these hearings blind or relying on the school to see reason for you. You got to be prepared to make every argument you can make for your student, because at the end of the day, if you're not making it, there's every chance that the school board is not considering it fully. So arm yourself with this information. Don't be afraid to get involved in the bad facts. And lastly, don't hesitate to seek help. Get representation. That's what we're here for. All right, so for my folks who are doing a CLE, we have a true or false question. The Supreme Court case establishing a student's right to a disciplinary hearing is Goss v. Lopez from 1975. True or false? All right. Well, it looks like it is everyone I'm seeing got it correct. It is true. So for those of you who weren't sure, it's true. Next slide, please. All right, guys, this is my info. If you have questions, you're really not bugging me. I mean it. If you think about something an hour after this presentation or 2 weeks from now, shoot me an email. I'm happy to help in any way. I know when I get off of consults or calls with folks, I always think to myself, like an hour later, I go, oh my God, I should have asked that question. I feel the same way about presentations. I'm sure I may think of something 2 days from now that I'm like, oh, I wish I'd addressed this too. If there's any gaps, if there's any questions, feel free to reach out. And I think we have a little bit of time for Q&A. If there are any questions, I'm happy to stay on and answer.
Hey, Megan, I'm going to jump in. This is Ruth. We got
Thanks,
a
Ruth.
question earlier. You answered a question about suspensions carrying over into the next school year and stated the difference between Michigan and Ohio. And we just had one little minor correction because in Ohio, suspensions only can be up to 10 days. And it is true that they don't carry over to the next school year, but the clarification and the question was, do expulsions roll over? And indeed, in Ohio, they can roll over into the next school year. So the question for you then is, in Michigan as well, if a student is expelled, does that expulsion carry over, or is there some other way that it's handled?
Yes, thank you, Ruth. And I appreciate you jumping in. Like I said, folks, I'm not, an Ohio attorney, so I appreciate Ruth's perspective and correction. She's absolutely right. It can carry over in Michigan. So if you have a long-term suspension, say 30 days, and you have 5 days left to serve, that will carry over. If you have an expulsion, which in Michigan is typically 180 school days, and then you can apply for reinstatement. Actually, you can apply after 150, but you can't be reinstated until 180. It's pretty annoying, but that's just the state of the law here. In Michigan, that will carry over. So for example, if your student is expelled for 180 days, let's say in April, number one thing I definitely want folks to be aware of, and again, it's no fault of anyone's, it's just a confusing process. I will often hear from parents who say, well, it's been 180 days. It's not about the days, it's school days here in Michigan. So those expulsion days, it's 180 school days, which, as many of you know, is almost a whole school year. So if your student is suspended for 180 days in March, they're not coming back in September at the beginning of the school year here. That will carry over.
Hi, Megan. This is Nicole. We have a question regarding the 7 factors. Um, Someone said they have, I'll just read it. They always encourage parents to bring up the 7 factors when the student is suspended, and they get a mix of responses from the principals, including, we don't have to disclose how we considered those factors, or they don't understand when to consider them, or how to do restorative practices. So the question is, at what point should the 7 factors be considered? Is it at the time of suspension, at the time of the disciplinary hearing, before an NDR? Because it seems to be a mixed bag. Wondering what your thoughts are on that.
Yeah. So technically, they have to consider it at the disciplinary hearing. However, I bring them up every single chance I get. And the reason why is twofold. Number one, like I said, these are a really broad blueprint that kind of comprehensively covers all the concerns that you might have for your student, and all of the factors that may weigh in their favor. Number two, because it shows the district that you know what you're doing and that you're not going to be led around by the nose at a disciplinary hearing. So I usually bring them up at an MDR. I bring them up at an informal hearing, when I meet with the principals, and they may say, oh, we don't have to consider those right now. And I say, well, you're going to have to. So let's start right now. And I like to lay my record that way. But yes, it is required that they do it at the formal disciplinary hearing.
Thank you, Megan. We have another question can some of this information be carried over to community-based ECE programs as it relates to expulsion? So many preschoolers get expelled and discriminated against in preschool.
Ooh, that is a good question. I have to be honest, guys, I've never dealt with that situation before. I'm not entirely sure. I would argue, certainly if it's being run through a public school district, then absolutely yes. I mean, there's no age limit on your student having a due process right. I don't know if any of the other attorneys here have dealt with that, if they want to jump in now, but let me think about that one as well. And I'd like to carry that over in the Q&A this afternoon. I'll see if I can find anything about that.
Absolutely. We do have another question. If you could provide some examples of behaviors that have led to expulsion hearings where you were able to secure a lesser form of discipline, and if you might share any other lesser interventions that may have gone along with those lesser forms of discipline, including the backpack checks, online with gradual return, and others. Those were all great, but if you have any other examples, that would be great. Thank you.
Awesome. Yeah. So I'm very fortunate and very proud to be able to say that anytime I have represented a student at an expulsion hearing, we have walked away without an expulsion. So we have wound up with those lesser interventions, whether that be a shorter term suspension, or a student having an immediate return to school, or a voluntary withdrawal. And those can look different. But let me give you kind of my favorite ones. And I say favorite not because I'm glad that the students engaged in these behaviors, but because I think that these were opportunities for the student to learn and grow. And also they were a chance to get a school district to really chew on the 7 factors. I had one incident where a student was experiencing some bullying. And then the bullying escalated to verbal comments, very inappropriate comments about his sister. And I'm not condoning the behavior, but it was a situation I think most people can understand. He got very upset and he punched another student. At that point, the district put him up for expulsion. And this was a student with really no prior disciplinary hearing. Absolutely no suspensions, no prior expulsions. It was a kiddo with ADHD. So as I'm sure we have, parents here who their kiddo may have ADHD. I'm sure I can say something you can relate to here when I say that he was impulsive, right? And he made choices quickly, and sometimes they weren't the best choices. But kiddo had ADHD, and the most on his disciplinary history was impulsive things, being tardy, forgetting things, the things that kind of come along with ADHD, maybe talking a bit too much in class. And this was one where, unfortunately, we went to MDR. The district did not side with us and put him forward to expulsion. Now, I still, in my very bones, feel that this was an impulsive decision that was influenced by his ADHD. That aside, we were able to go to the disciplinary hearing, and by leaning heavily on these 7 factors and suggesting lesser interventions, we were able to convince them to let this student return to school. Now, one thing that we used in this kiddo's case was we ended up agreeing that he would agree to change his lunch hour. These 2 boys didn't have class together. Where this incident happened was in the cafeteria during lunch, and thankfully it was pretty easy because they weren't in courses together. We submitted that as a suggestion to the district. It was not something that they submitted to us. We were proactive and we said, look, we understand that you're concerned that these 2 boys are going to fight in the hallway again. Here's how we avoid that. He'll move his lunch hour, or he'll agree to take lunch in the library. And he recognizes that this behavior wasn't appropriate, which is why he's willing to do that. And in doing so, we separate these 2 students. So that's one example of a lesser intervention that, it seemed kind of obvious at the time, but no one had brought it up, and it worked. That student did successfully in school and managed to move on, and he's doing just fine today. Another such example for lesser interventions, and really, I want you to feel empowered to negotiate these. One that we had a while back involved a student who was being disciplined for giving another student a marijuana cigarette. Definitely not something we want to see our kids doing, right? But he did it. He's 14. He wanted to look cool. He made an impulsive decision and he regretted it. So the district wanted to do multiple backpack searches throughout the day. And it was to the point where the student would have to get their backpacks searched out in the hallway and their lockers searched in front of all these other students. And that was something that understandably, I think, would have been really humiliating for this kid and would have set him up for less success when he got back to school. Would we have agreed to it if we couldn't have talked them down? Of course, because at the end of the day, we want your kid back in school. But we pushed back and we said, okay, look, we understand that this is a lesser intervention you're offering. How about we do it this way instead? Why don't we check in his backpack at the office? You can search it and keep it. He'll take his books to his locker and operate from there. And that removes their need to search him for some non-existent marijuana cigarette that I guarantee this kid's never going to bring to school again, right? Because this whole process was so scary. And it was a lesser intervention that we were able to work out in a way that was more convenient for the district and also saved the student from feeling humiliated and ostracized from his peers. So I guess the long-winded but main message here, guys, is don't be afraid to get creative with those. We can ask for the moon, right? If there's something that your student is willing to agree to as a lesser intervention, don't be afraid to push it. It's worth a shot. All right. I know I am almost out of time. Anything else that I can answer for anyone?
No, we had one more question. We did answer it in the Q&A, Megan, so I think we're in good shape there. In regards to threat assessments, if anyone didn't see it, you can take a look in the Q&A at the bottom and you'll see the answer to that. But I think the timing is good to do the evaluation if we can, and then take a 10-minute break.
All right. Well, thank you guys so much. This has been great, and I hope it was helpful.
It was great. Thank you, Megan.